Good afternoon, everybody, and welcome to this Business New Zealand webinar on Employment Relations Update. I'm Paul Mackay. I'm the Employment Relations Policy Manager for Business New Zealand, and I'll be going through a range of things on the employment relations space over the course of the next hour and a bit. For those of you in the room in Auckland, just health and safety, the doors are the main doors that you came out to exit if there's an emergency, the main doors you came in. And facilities and things are just around to the left. You'll need a card to get out. For those of you watching from home, you'll know where those things are, I'm sure. So without further ado, we'll get into the main body of things. I'm going to cover off several things. Hang on. If I can get this slide to go forward. Okay, so as you can see, there's a few things to cover. We'll spend the bulk of the time on fair pay agreements because that is the area which is likely to cause the greatest issues downstream, although there are a number of other areas that are both connected to that as well as important in their own right, which I'll also cover off as we go. So starting with fair pay agreements, as you know, the government campaigned on these, in fact, has been long announced the fact that it would want to bring in fair pay agreements as far back as 2011. It got in 2017 and has progressed its work in this area since. Of course, during its first term, it was held up in this area by New Zealand First, who were not keen, but now that it can govern alone, it's progressing at pace. There are a lot of issues with fair pay agreements, and we'll cover off the bulk of the main ones in this session. If you have questions, please stick them in the chat box and we'll see if we'll deal with those in chunks. So when I get to the end of the fair pay agreement section, we'll deal with those and so on through the agenda, if that's okay with people. So fair pay agreements, as an overview, they will be a single agreement that will cover either an occupation or an industry in its entirety. For instance, all of the staff in restaurants generally, or waiting staff, depending on how it's constructed. The bargaining for these things will take place between organisations, unions on behalf of employees, and industry organisations on behalf of the employers that will be covered by the agreement. So, for instance, if a fair pay agreement was claimed for restaurants, then the Hospitality Industry Association would likely be the lead agency for negotiating those. The government has campaigned on the basis that strikes will not be permitted for fair pay agreements, but as I'll show you later, they will be for anybody that wants to bargain at the enterprise level to top up what might be in a fair pay agreement. And the other main piece of information is that they'll be governed by standalone legislation. It will not be an amendment to the Employment Relations Act, as some people might have expected. It will be standalone legislation that will govern fair pay agreements. There's two ways to get a fair pay agreement. The first is through the normal process you would expect of initiating bargaining, the bargaining process, some form of vetting to make sure that the document is kosher, so to speak, a ratification process, and then finally bringing it into force, and I'll go through the details of those. The second way is through litigation. So if there are disputes at any level or any part of the process, that will go to arbitration, initially in the form of the Employment Relations Authority, and then perhaps later there will be a standalone institution dealing with these things, but at least to get it running, the government proposes to use the Employment Relations Authority to settle disputes, and those disputes will be by way of arbitration, and the decision of the authority will be final. There will be no appeals insofar as they relate to the conditions of employment. There may be the ability, and it's not decided yet, there may be the ability to appeal on issues of process where there's some contestability. But the overall arching goal is that there is no way out of a fair pay agreement once one is initiated. That is the underlying overriding message that everybody has got to have clear in their minds. You cannot opt out of these things like you can with MECAs, or not conclude one as you can sometimes, for most of the time, for a collective agreement, a normal one. This one is designed to deliver a fair pay agreement by hell or high water. Just go through the stages now that you saw on that brief diagram. From an initiation point of view, only unions will be allowed to initiate a fair pay agreement. And they'll initiate that by proving somehow, yet to be decided, that they either have 1,000 members or 10% of the workers that would be covered by an agreement want one, or by a public interest test. And again, the criteria are not clear, but MB would in fact play a major part in deciding that where a union wanted to initiate a fair pay agreement because it believed there was a public need or a public interest in doing so, then MB would make it a call on whether or not that criteria was met. Those criteria so far are yet to be developed. At the moment, the cabinet papers that have authorised this have put a suggestion that there would be a public consultation process to see if there was indeed public interest. So not so much that the union just simply says there is, but there would be some kind of contest or some testing of the waters about whether that would happen. But the key point though is initiation is solely and utterly in the hands of unions, not employers. Coverage, that's in terms of who would be covered by an agreement. The union, when it initiates, will also specify whether it wants the document to be an industry-based one or an occupation-based one. And within those general categories, it will also specify whether or not everybody in that industry or occupation would be covered, or subsets. So for instance, all restaurants in the hospitality industry or just chefs would be an opening claim, if you like, from the union. And that then would be a bargainable issue in terms of what the coverage would finally be. But of course, if there is disagreement, then the arbitration process would take over. So again, if there was a disagreement that it shouldn't be everybody in the hospitality industry, it should only be chefs, and arbitration said, no, it will be everybody, that will be the end of that story. The other thing is that they intend to put penalties in so that if there is an incentive, or people thinks that there's an incentive to reclassify employees, say as contractors, and contractors will not be covered, at least initially, by fair pay agreements. So there's the kind of off-the-cuff reaction saying, well, fine, I'll just make everybody contractors and we'll work that way and we won't have to be covered by these things. The government's making it very clear that it intends to put a net out to catch that kind of activity and penalise it if they find it occurring. Representation, this is going to be another vexed one. As I said, registered unions, and only registered unions, will cover employees. It doesn't matter whether they're employees who are union members or not. It's the union that initiates that will have the coverage authority, if you like, along with any other unions they agree to work with, that will have the coverage authority over all of the workers that would end up being covered. As I said before, for employers, it will be industry organisations where there is one. The government has proposed a default that should there be no industry association, then as occurred back pre-1990 in the old award system when the Employers Federation was the kind of predecessor to Business New Zealand, was the default employer. They've proposed to repeat that exercise now. Now, whether or not we want to play ball with that is another matter again, and this perhaps Kirk, who's here, can comment on that later. But this is the proposal that government currently has out there by virtue of what it's approved in Cabinet. So what we do with that, of course, is yet to come. The other thing that's interesting is that the Cabinet paper approves that other interests, whatever the other interests might be, can be represented if the primary union and employer representatives agree. Reading the fine print in the Cabinet paper, there are things like Maori interests or ethnic interests or other interests that may not be covered directly by that particular union or that particular association can also be brought in. That's an area which is itself fraught with difficulty in terms of what can be said, done, and who has what kind of bearing on the outcome of a fair pay agreement. Notification. Throughout, you'll notice and see in words of one syllable really, that this is incredibly bureaucratic. So notification is once a union notifies the relevant employer organisation that it's got a claim, the employer organisation is going to have to contact unknown, all of the employers that would be covered by the agreement if it was to come into force. And now that's going to be challenging. If you've got the clerical work, for instance, and the unions have long been interested in a clerical work fair pay agreement, there are just over 300,000 businesses in New Zealand that would be covered by that kind of agreement. So how on earth, in fact, who, for a start, but how on earth you could contact that number of people and let them know that they are going to be covered by the incipient agreement is a challenge that's beyond the resources of almost anybody. And once we get further down the track, I'll show you just how unwieldy that also becomes. The other thing which is going to cause some angst is that those employers, once contacted by the representative, are going to have to let the union who's initiated the document the details of their employees, union members or not, because the union will need those later for voting purposes, apparently. But then apparently there is the ability to opt for an employee to opt out of having their information provided to the union. And as again, like with the employer side of things, papers, there will be a huge amount of administrative difficulty in managing that. In terms of the process, one of the things that's ironic about the fair pay agreements is that when we had the old national award system in the 1894 right through to 1990, the government hadn't done two things. One is it hadn't introduced the concept of good faith, which it did in 1999. And the other thing was that it hadn't ratified the international convention that covers collective bargaining, and it has a number of principles which are also challenged by this. But now we do have good faith, and that does mean that the employer representative, taking the employer perspective, is going to have to act as if the people who are not their members and who are out there remotely are their members and take their interests into account. Again, the administrative and practical challenges of doing that are legion. The other thing was, of course, at the bottom of that, is that specifically Maori interests and views will have to be considered in the whole process of bargaining for any given fair pay agreement. And again, the diversity and challenge of what those things might look like and be, and how, for instance, if we're talking about a fair pay agreement for clerical workers, which is a highly generic occupation, that sort of thing will be manifestly considered or demonstrated to be considered, will be challenges in their own right. And remembering that every one of these things that can be challenging can also be challenged, in the sense that these are all opportunities for litigation and dispute that would then go to an arbitrary process. Again, with the process side of things, we've long had arguments throughout employment law about union access to workplaces. But currently, the way it stands is that unions have free access for members and for reasons related to collective bargaining. The proposals here are to extend that access so that where employees are employed in a workplace that would be covered by a fair pay agreement, unions are going to have free access, or under these proposals, unions are going to have free access to all workplaces where they might have coverage, as opposed to where they might have members. Now, that's going to cause practical issues for an awful lot of businesses around the country. It's also going to cause problems for unions who, if you've ever followed the history of unionism in this country, has been declining steadily for many, many years. And in the private sector, which is where most businesses, all businesses really, there is less than 9% coverage these days. So the number of unions, there's 135 unions left in this country, with the number of officials employed by each being very small. Their ability to get to workplaces is going to be very, very limited. And they're already talking behind closed doors with government about having to use delegates from workplaces to go and visit other workplaces. So there's iterations above what you're seeing here, which is all what is in the cabinet paper, that will take you to a point where involving your own workforces to go out and visit other workforces is rapidly going to become a conversation as well. As you'll know, for those of you that have collective agreements in your workplaces, that union members are entitled to two-hour meetings per year as part of the Employment Relations Act. This proposes two more of those that would be part of the Fair Pay Agreements Act, or whatever it gets called in the finish. And those will be additional meetings for the purposes of discussing fair pay agreements. How and when they'll be used at the initiation end, or during the bargaining end, or at the ratification end, is up to the unions concerned. As I said before, no strike action during bargaining for a fair pay agreement, but there is no restriction at all on strikes that would take place for secondary level agreements where a fair pay agreement, for instance, has been settled at a very basic level and the unions want something more at an enterprise level and initiate bargaining for that. All of the normal rules for collective bargaining under the Employment Relations Act will continue in force, and strike action, of course, is permitted for that. In terms of what has to be in them, at the moment, there are some things that must, according to the cabinet paper that approved these things, there's some things that must be in a fair pay agreement, and the obvious ones being the wage rates and how they're changed, how superannuation has worked, your hours and penal rates. Mark that word, penal rates. It's a phrase which is not that often used these days. It certainly was back in the award days, and it is coming back. The coverage, of course, who actually is bound by the agreement, how long it will last, and the various governance arrangements that typically go around how collective bargaining works. Those are things that will have to be in the fair pay agreement. There's another list of things that will have to be bargained over during the process. In other words, it'll have to be shown that those issues were considered and discussed, but they don't have to be put into the agreement. So there is an area where things can be argued over and perhaps left to lie, but they include things like redundancy compensation, leave, the objectives of what the fair pay agreement's about, skills and training issues, which of course will have hugely differential perspectives depending on where in the country and what part of an industry people are in, health and safety, and things like flexible working arrangements, which of course with things like COVID, working from home, we're seeing a lot more of, and we can expect to see flexible work becoming more of a common agenda item in all forms of collective bargaining, not just fair pay agreements. The process allows for some limited outs. The proposal is that the parties that are at the table can agree to exempt some employers, but where they can show there's financial hardship if the deal was going to be too damaging for them, at least for a short period, not permanently. There's a temporary out that is proposed. There will be an ability for the document to capture regional differences, things like housing prices in Auckland or whatever would be able to be captured, but they are stopping short of allowing different fair pay agreements to be developed for different regions or different parts of industries. They want one document per nation, per occupation or industry, with agreed differences where people agree that they should be there. And there will also be some ability to capture things like progression through wage rates, for instance, whether or not it's on a skills basis or some other form of basis, some form of differentiation about how people may be paid differently because of things like skills or experience will be able to be discussed. There will be a vetting process. In other words, when people have done a deal at the table, it will go to the arbitration authority, in the first instance, as I said, the Employment Relations Authority, and that will have a role in making sure that everything that has to be there is there, that everything that is allowed to be there is there in a form which fits with the intent of fair pay agreements, and we don't quite know what those criteria might look like yet. If there are issues that the authority finds with the way that the document is either agreed or what's in there, it will be put back to the parties to resolve. But if they can't resolve it, there will be an arbitration process, and again, the authority's decision will be final. So as you can see, the thematic through this is not only can you not escape these things, but if you can't do it sensibly around a table, somebody independent of you will make the decision for you. Ratification. I mentioned before at the initiation phase that there were huge ramifications, and this is where one of them stacks up or shows up. So ratification in the present circumstance with a collective agreement is that having done a deal over the table, unions typically take the deal to their members who vote. And if they vote yes, then it's a done deal. Employers don't vote because employers don't make offers in collective bargaining that they're not prepared to agree to. So there's never been a requirement for, even in a MECA situation where there's more than one employer, there's no requirement to vote because the expectation is that those at the table had the authority to settle, and that's it. Here now, though, there will be many employers probably who are not even party to the conversation. They may be represented and they may be covered, but they won't be at the table and they won't have the ability to say yes or no at the time the deal is done. So there will be, under this proposal, a voting process for employers too. And that's proposed to work on the basis that for every employee an employer has, that counts as one vote. So in a sense, every employee that would be covered would vote for themselves, and every employee covered by an employer that would be covered by the agreement can be counted by the employer as a vote too, if they want to vote. The government in its wisdom has decided that because small employers have very few employees, there needs to be a weighting process. And the way that will work is that an employer with one employee will get 2 employee votes, all the way up to 20 employees, where it will peter out to 1, and everything above 20 employees will be 1 vote per employee. I think the dilemma is now obvious, is how the hell is anybody going to know, have you got all of the employers that need to vote covered, and they all know that they're actually going to be covered, that they can vote? And secondly, you're going to have to go out and find out how many employees every employer has so that you can count the votes properly. And I mentioned before the extreme example of clerical work with 300,000 odd employers. It is simply not possible. So, this pervades the whole process. The mechanics have been invented in a way to satisfy the needs of government, but they haven't been invented in the way to satisfy either employers or employees, for that matter, or unions, or for that matter, common sense, full stop. Again, with the ratification process, if the ratification vote fails for any reason, it will go to the arbitration authority, who will try and fix it up or make a recommendation. If the vote fails a second time, the fair pay agreement terms and conditions will be fixed by the authority. It won't go back for another vote, and it won't be a no agreement vote like there is for a collective agreement now. There will be a fair pay agreement. It will be fixed for you by the authority. So ratification in that sense is A, it's mechanically, physically impossible under the rules, and B, it doesn't mean anything, because if you don't agree and you don't want one, you'll still get one. And you can't appeal. It's the terms and conditions that are fixed by the authority. According to the cabinet paper, there is no right of appeal. So that'll be it. One of the things, again, the bargaining parties will be required to keep records. So I made, the point I made before about having to find all of the employers who are going to be covered and how many people they have employed, so that the vote can be accurately counted, will be an administrative, physical process that an employer organisation will have to follow. MB will then take on a judicial role as well. It will be like the returning officer for elections. It will be required to audit votes and check that the votes were conducted properly and that they were covering the right number of people and the right number of businesses. And there will be some ability to have a judicial review. And it's not clear what the judicial authority would be, but it sounds a bit like, there's still debate going on in MB about this, but one of the thoughts they have is that it would go through the same process as electoral results would be in the High Court, in fact, would be the Judicial Review Authority. That's not decided, but it is part of the mechanism that's being discussed. Dispute resolution, as I said, you've seen it right throughout the whole process. The basic dispute resolution process, mediation through to the authority for, first of all, a recommendatory level kind of approach, and finally a fixing based approach. Same basic process provided here. It will mirror the employment relations. The only differences will be that there will be no mediation in advance of arbitration where the bargaining hasn't started, but the process has been initiated. But after bargaining starts, there will be a mediation process for any dispute before it goes to the next levels. Getting it into effect, typically a collective agreement comes into force once the employees have voted yes, the terms of settlement are signed, and effectively that brings the document into force, and it continues then until its expiry. Here, the process will be that a settlement will then go to MB, who will convert it into what they term secondary legislation. It'll be a form of regulation. So MB will convert the settlement into legislative language and pass it through an order in council to turn it into effectively an order in council. that means that the MB will redraft what the people negotiated at the table to turn into law. Again, there are processes and potential for litigation and dispute about what was said at the table and what was converted into legislation. But like what we go through now with select committees and various other things, you know, the process of getting from what we meant to what we got will be fraught here as well. Compliance and enforcement, much the same as we see now. The Labour Inspectorate will have its traditional role, but there will be a different penalties regime. While the bargaining is going on, if there are penalties to be applied, or if there are offences committed against the process, then the penalties that might be applied will be higher during bargaining for a fair pay agreement than they will be afterwards. But other than that, you can, if you're familiar with the way that labour inspectors work, that will be much the process that is proposed for the fair pay agreements process. Variation and renewal, of course, once something's been settled and is enforced, there are always the chances that something that comes up that people want to change during the term of an agreement. That happens by agreement now. So one or the other party to a collective agreement can put forward a proposal for variation. It's bargained over, but if there's no agreement, nothing happens. As simple as that. Here, there is a need to recognise that potential, but at this stage, there has been no decision taken nor a process even recommended as to how that process will actually work, because it has things like, who do you bring back to the table for the variation process? Is it the same group that negotiated the first deal, or is it those that are more connected with the need for the variation? And there's a whole lot of issues, practical issues as well as legal issues, that are yet as yet unresolved. But it's a necessary feature of any collective bargaining process, and it will need to have an answer at some point if they want to push this thing through. Or the other corollary to that is that they can't find an answer and they don't push anything through because they can't make it work. It's down the track a bit. Let's just talk a bit about what this might mean in terms of the various impacts, and then perhaps we, because then we'll move on into other areas. But as far as the overall impacts of the fair pay agreement process is concerned, whether or not the government's prepared to admit it, it is reintroducing almost a mirror image of the award system that existed prior to 1990. And as early as this morning, or as late as this morning, the unions have just realised something which has been known to employers for some time. The old award system exists only in a set of books. They cover from 1894 through to 1990, and they exist in libraries. They are not digitised. They're not available for research other than people who have access to a library like that. And I have now seen some information out of the union movement today that is they're talking to government about digitising a set of those for use in preparing fair pay agreements. So in other words, they want the old award system to inform how fair pay agreements can be negotiated in the future. So yeah, again, if there's any denial from government about recreating the past, there's another particular pointer to the fact that they actually are. The other thing is, and this goes all the way back to the Fair Pay Agreements Working Group, one of the objects that was stated earlier in the report is the need to have a more equitable process for outcomes of collective bargaining. And the net result of the proposals is that while they may achieve more equality, in other words, everybody squashed into the same box, there is nothing in the proposals nor in the past of these things to indicate that productivity is an outcome of the fair pay agreements process. So in other words, we will get more equality, we will not necessarily get more productivity, despite the fact that New Zealand's relatively low productivity was a key reason for initiating these fair pay agreement discussions in the first place. One of the things that people don't realise about fair pay agreements is, like the award system, if they're going to cover everybody, then they're going to need to settle at a level where everybody can in fact live through the outcome of the bargaining. There is no point settling at a vastly higher wage level, for instance, for a large scale occupational class where the bulk of them are employed by big employers, and the settlement then would take quite literally the cost prohibitive costs on skills for smaller businesses. So the history of these things is they will typically settle at the lowest common denominator, the lowest common survivable denominator. That means ultimately they are not vehicles for high wages and high outcomes for employees. They're simply a mechanism for normalising things at a low level. And they do incentivise people to go and do their own deals outside the structure of these things. The other thing that people don't realise is the more money people get with the prevalence of things like working for families, it's very rare for people to get the full value of increases these days, because particularly when we're talking about the low end, which is where fair pay agreements, at least initially, are targeted, most people at the low end of the spectrum are in the working for family situation at a level where the more money they get, the more their working for families provisions will abate. And so if you do some maths, with just some tax tables and the fair pay, the working for families rates, and throw in an increase and find out that, roughly speaking, people will get about half the value of an increase. So not only will they be lowest common denominator increases anyway, but the value to employees gets taken away by things like the transfer payment system that government already operates. The relativity arguments, again, we haven't heard these words since the award process finished, but basically the old system used to work on the basis that a key document would be settled and everything else fell into line after that. The metal trades award in the private sector would start a process that then led to electricians, to you name it, one after another like dominoes. And in the state sector, it was secondary school teachers who drove a series of relativities that finally ended up affecting people like school audiologists. So it is again that we see it with the minimum wage. If you push up the minimum wage, then there's pressure on the level above the minimum wage because the gap between the two is compressed. And of course, those who are supervising or in managerial roles believe for good reason that they should be paid differentially because there is a difference between what they do and what the working level is doing. So it is with fair pay agreements. The settlement for clerical workers, for instance, or for electricians maybe, will lead to a view that electricians aren't worth as much as a plumber or a carpenter or something like that. And so that then the ball starts rolling with all of those other occupations. We haven't seen that because we've been in the last 30 years in an enterprise level bargaining process where everybody's working inside the common market that is their business within their industry. But this brings back that argument about what an occupation is worth versus another occupation. Unions will miss out too. As I said, only a union can initiate an agreement, and the initiating union effectively has the whip hand. If I use clerical workers again as an example, there are 30 unions that cover clerical workers in terms of the 130 odd current unions that are registered. Only one of those, the PSA, is affiliated to the Council of Trade Unions. The other 29 are little unions who just represent the workers in that particular workplace. And the chances are that they will not get to the table to represent the workers if, say, for instance, the PSA decided for a clerical workers claim. So there's very big potential for a lot of smaller unions to, in fact, be left out of the process, have the coverage of the work that they currently deliver value on taken over by an agreement that is generated through the membership of a different union. So there's no great success for a lot of unions either. As I said before, and I'll show you in slightly more detail in a minute, it's an absolute recipe for disputes and litigation, none of which actually help anything other than helping the lawyers and litigants in the process get through the process. It doesn't help productivity. It certainly doesn't help confidence or morale. And it is a long time-consuming process that does nothing to enhance enthusiasm for a mechanism like this. And lastly, and not least, it breaches international law in a way that is not obvious to the ordinary observer, but New Zealand ratified the Right to Organise and Collective Bargaining Convention, which is an ILO convention which binds New Zealand because it's ratified it. And the key principle of that convention is free and voluntary collective bargaining. And as you can see already, there's nothing free nor voluntary about what is proposed. So there is a background process going through all the way up to the ILO, making sure that the government is aware of its obligations under international law, and that will go alongside all of the things that will come down the track in the near future about our domestic response to fair pay agreements. And the other thing is it won't be just one or two. I think we've all heard Jacinda back in the early days after the election saying, oh, there'll only be a couple of these things in the first year. There won't be very many. but by their own admission, the cabinet papers that were released publicly a week or so ago have been built on the assumption that it will be at least 8 to start with, and that many more in succeeding years. So I think the government has bitten the bullet at least and said, we can't control how many there are, because to control who is allowed to bargain would be more than I think the government's union supporters can bear. There are a lot of unions lining up with a lot of claims, and I don't think any of them want to be at the back end of a queue that's only too long. So there's going to be a lot of pressure, I think, even internally, as to how many there are in the first instance. I think the government is trying to control it a little bit by announcing that it would fund the first few. So in other words, the first 2 or 3 cabs off the rank might get some assistance in terms of going through this process for the first time, but those who come later may not get any help at all. And again, that won't enthuse unions any more than it will employers, for that matter. If we look at, again, that diagram I showed you can't escape. In terms of the bits in the middle, the initiation process has a lot of steps in it. These slides will be available, by the way, so you don't have to take too many notes, but I'm just using this as an illustration. So the initiation process has a lot of pieces to it. So does the bargaining process, including the bits you have to bargain for and the things you can bargain for. The vetting process has the authority and the MB involved in it. The ratification process has those steps I mentioned, and then the bringing into force has those steps I mentioned. The important thing about this, and then there's all of the mediation and disputes processes. The important thing about this diagram is not the detail of each step, but what those colours mean. So everything that's in red has potential for litigation and dispute and arbitration. If you look at the current collective bargaining process for an ordinary collective agreement, there are about 3. So there's a vast increase in the potential for dispute and litigation. The ones with the black rims around them are clear breaches of international labour law. So those, just as a picture, it tells you that this is not a process that is designed to help business become more productive or the economy grow. It is in fact purely and utterly a process that helps unions grow. It doesn't help anything else or anybody else. Just in terms of impacts again, this graph shows strike action from 1921 through till now. So in other words, 100 years worth of strike action. That massive spike in the middle, you see there's 1970s and 80s when the award system began to collapse. As I mentioned before, awards typically delivered very little. And in 1968, they delivered nothing at all. And that started a ball rolling where unions in those days had to be registered under the Trade Union Act and the Arbitration Conciliation Act, and therefore were not allowed to strike. What unions began to do was deregister from that process and bargain at the enterprise level on top of what was already there for awards. And of course, they can and did strike, well, they could and did strike a lot during that process. Then we got the Employment Contracts Act, which introduced enterprise level bargaining as the preferred level of bargaining. And even the Employment Relations Act in 1999, which reintroduced a preference for collective bargaining, didn't move away from the enterprise bargaining model. And you can see that for the vast period of time from 1990 through till the current government came back, strike action in terms of what was lost to strike action by way of working days was exponentially lower than anything that ever occurred under the award system. We've seen a big hike in strike action since Labor came in, even under the current system. A lot of that's related to the state sector and with things like pay equity and nurses and teachers and so on. But there is quite a bit out there in terms of a number of other areas as well. But it is the expectation that unions will get what they want that has fueled a lot of expectation that hasn't been delivered on, particularly in the state. And the cost to the state of a state sector deal like nurses is more than even the government can bear, and it's showing up in frustration with the working for, the teachers, the doctors, the nurses, and so on. So you're seeing that showing up now, but we can only presuppose what might happen if there is so if we look at the comparison, if we look at the occupational award system that underpinned much of the time pre to 1990, we had that period of enterprise bargaining on top of occupational awards, which drove the strike action in the 1970s and 80s. We've had the period of calm through to the purely enterprise period of up till now, effectively. And we have to now conjecture as to what happens if we have what is basically a mirror of occupational awards, and the fact that not only are second-tier bargaining permitted, it is actually encouraged. If you look at the cabinet papers that are publicly available, they envisage topping up of fair pay agreements with extra bargaining. So the environment that created the problem, or the rules that created the problem, have been eased from pre-1990, to the point that what caused the problem is now encouraged. If we think macro-wise, if we look at the country, our country versus other countries, there are 4 areas which we are economically most vulnerable in, and that's our arterial structure, infrastructure for transport and distribution. And I just throw the thought out to you that the idea of fair pay agreements, locking up whole sectors, in fact, puts more of our logistics and distribution at risk than almost any other area of the economy. So from an economic growth point of view, we aren't helping ourselves by going down this path. One thing that we did push back on at the very, very beginning, and Kirk Hope, who was in the working party, pushed this to the point that it was at least written into the agreement, even if the unions and government couldn't see its way through to agreeing, is to recognise what MBIE has now shown that it also realised. MBIE, when it released its economic impact statement in terms of what fair pay agreements might do, with the cabinet papers that were released last week, has clearly fought back against the idea of fair pay agreements in favour of something which is much more targeted. It sees value in having, if there is a problem industry, is having something targeted at that particular industry or occupation, rather than having something applied to absolutely everything in the economy. So the proposal that was put forward at the time of the working group report was, where there is a problem industry with a bunch of employers in it, problem being defined in that there is clearly some imbalance either in the bargaining process or the outcomes or the like, then there could be a bargaining process that develops something in the nature of a code, which, if signed up to, could become what is already known as a MECA for those employers that sign it, and therefore binding, but otherwise just guidance for those that don't, through to a process where the normal rules for collective bargaining would apply. If it expires, it collapses to individual levels of bargaining. But there's also the capacity to review what's in the code and to revise it and re-promote it and bring it back in the form of either more MECAs or the like for that group of employers. As far as everybody else is concerned, they can continue as normal. That was the kind of base proposition at the time. It's still obviously an option going forward, and it's clearly one of the things that we will push for as one of the options going forward. So that's fair pay agreements at a very fast trot, and there's obviously a lot that underpins a lot of those comments. But in terms of the basic infrastructure for them, the process for them, the potential for litigation and dispute, and the sheer basic lack of democracy and fairness involved in them, there is nothing fair about fair pay agreements, is the bottom line for these things. So we'll take a couple of questions just at that level. Yeah. So the question is, what does give effect to Maori views and considerations mean? The answer is nobody knows. It is a phrase which is effectively borrowed from a lot of the state sector approaches to things like procurement, government policy, and it hasn't got a set of criteria attached to it at present. Because, as I said, what do you do if you have a clerical work claim, for instance, that wants more wages for clerical workers, wants more flexible work for working hours? How do you show that you take a specifically ethnic point of view in that process that is not either disparaging at one level or face value or a sop to those aspirations? How they will manifest and how you will show that you've delivered is simply not an answer that anybody has even got to yet. And so it stands there as a criteria, but it has no material answer at the present time.
all your employees opt out. Is that out of the fair pay agreement? Does that mean you should keep your own enterprise bargaining?
No. So the question is, say you've got a trucking firm and all of the employees in your trucking firm say, we don't want to be in a fair pay agreement. Can they opt out and simply be covered by whatever they're covered by now, or whatever alternative they prefer? The answer is no. If the union puts a claim forward for all truck drivers, let's just say that's all truck drivers, not just 18-wheelers or the like, then a deal will be done, and whether or not your employees like it or not, they will be covered by that deal. And so will you as their employer. There is no escape from a fair pay agreement once it's been defined as to what it covers. So again, we're moving on at a fairly fast trot because there's quite a bit to cover. The next big area that's currently under review is the area of contracting. You'll remember last year, the government put out a discussion document for so-called better protections for contractors. This comes back to something that the government has long held as a manifesto issue, in that it wants to extend the right to bargain collectively to contractors who currently have no employment-based rights. They don't have leave or the ability to bargain collectively. They pay their own tax and so on. And they want to introduce statutory and support and legal rights for dependent contractors, who are loosely defined as a contractor who is only the one client. In other words, they're dependent on that particular client for their business. And if you looked at them closely, they're probably employees. The consultation document last year went out for some months, and over the Christmas period, it was pulled back together again by the people at MB, who have now produced a document looking at all of the responses. And the government has now convened a working group, a very small working group at this stage, to look at what those responses were and what options might be considered for dealing with the concerns that the government has about what might be regarded as exploitation in the contracting world. Their focus is areas where contractors have conditions where the outcome for them is a very small income, potentially less than the minimum wage. What a lot of people don't recognise, or at least don't openly recognise, is that groups who are disadvantaged in that way are the very small minority of contractors. The vast majority of contractors, and you think here, anybody who's self-employed, tradespeople, even lawyers and doctors in the main and self-practice are contractors. They're operating from client to client, are not that badly off. So we're dealing with a relatively small level of the economy, and like fair pay agreements and like many of the things the government proposes, the response is basically to change the economy to suit the needs of the small groups that are the focus of their attention. If we look at what the government proposed in its discussion document, they came up with 11 options. I've grouped them in a way that shows that they divide themselves out at a regulatory level and a strategic level, but roughly speaking, they are not wedded to any particular one, but if you listen to the kind of press and publicity around various issues, you can see an enthusiasm for changing the rules is very much on the minds of people like the unions. So we see, for instance, in the press in the last week, the challenge to the Uber situation, where the first union is taking Uber to court on the basis that it's arguing that all Uber drivers are employees. Now, of course, if the court says yes to that, then there's a change in the whole dynamic of the platform-based industry. Likewise, if dependent contractors, people who have only the one client, are deemed to be employees, by legislative fiat, that will change the entire dynamic of contracting. The government's only just coming to grips with the fact that it employs thousands and thousands of contractors itself, primarily to get away from sinking lid type staffing levels. But they have a lot of people who are simply bound to a particular department doing a job that otherwise an employee would do. And so it will itself face some practical ramifications if it goes down any one of these paths. To date, the process has only just begun. So the working group has heard from a small number of representative groups like Uber, like people like courier firms, trucking firms, delivery firms, and so on, and a number of unions and individuals and academics, just to get a feel for whether or not the problem is as endemic or as specific as the government has indicated it might be, or whether or not there is a broader set of things to be considered. It has not begun any consideration of those 11 options per se, and it probably won't for at least the bulk of the rest of the year. The expectation is that group will report back to the government with findings on what it feels are issues and possible responses, not necessarily with recommendations for particular responses. So it's going to be an iterative process and a longer track one. There's no specific time frame for anything in the form of legislation because there's no specific proposal, and it may be that it doesn't see the light of day before even the next election, especially given what else is on the government's legislative agenda. It's possible that it might take a while. The question of redundancy. Labor has long campaigned for the idea of a statutory minimum entitlement to redundancy. Back in 2008, just before they went out of power, when John Key came in, they in fact produced a report that recommended a specific redundancy compensation package for every employee in New Zealand. In 4 weeks for the first year and 2 weeks thereafter, up to 20 years, which if you add that for every employee onto your balance sheet is a tidy sum for any company. The issue for employers, though, is, as I just said, a statutory minimum entitlement goes on your balance sheet. It means that the value, quite frankly, of every business in the country is changed by virtue of that liability, and it changes the dynamics of how people perceive that business, both in terms of running it and also getting it out of trouble if it does need to restructure or take a different form. And if we look at the European Union, when it introduced things like the so-called Acquired Rights Directive in the early 2000s, the insolvency rates in countries went up hugely. In France, insolvency rates in 2003, 2004 went up 23%, largely off the back of these liabilities being created. So the issues for us are to learn the lessons of what happens when you do that sort of thing. And that has in fact been a point where we can claim that the government has in fact done some listening, because the conversation that the government is now engaged in is whether or not there is a better way than a statutory minimum entitlement. And for want of a better word, they've called it social insurance. I think that's a better term, and a term we should promote if we're engaging in this conversation is one of employment insurance. The idea is, if we take ACC as the analogy, ACC is a process where if you get hurt and can't work, ACC system will pick you up, support you economically by paying 80% of your wages, and rehabilitate you using the health system. Conceptually, the idea of a person who's laid off or made redundant could be picked up using the same basic concept, a system which would support an employee during a period where they can be retrained or recalibrated, if you like, towards a gainful employment at much the same levels as they were before. So that conceptually is the idea, and the government has in fact picked it up and decided to run with it to this extent that we test it and see if it can work. The idea at the moment, and the government's working on it as a baseline proposal, is it would be working alongside and as part of an ACC concept, where in fact the cost to employers and employees would be run the same way. Employees would pay more on their wage, employers would pay more in ACC levy type levies, at a level which would be very small, a few cents per payday, kind of small. That's the concept. And diagrammatically, you can see it very quickly there. If a person's made redundant, they can be given support, and they can, if they're hurt, then they can go through the ACC system. If they're redundant, they can go through the education system and back into meaningful employment, or failing that, the existing social welfare infrastructure can stay. The fly in the ointment, if you want to call it that is the pure concept of it, and it's manageable at that level. There is enthusiasm, though, from the government to have it at a different level. But just first, even at the level I've just discussed it, just purely in terms of responding to redundancy, there are a lot of issues to be covered, a lot of issues to be sorted out. And at this stage, there are no final decisions on any of these things. But things like who would be able to get it, how long would it be available for, what would it cost in terms of what would people have to pay, who can, how do you get in there, how long do you have to be contributing to the scheme, for instance, how much will you get when you're on it, what happens if you only lose some of your income by virtue of redundancy. what happens if you play the game, or don't play the game rather, and game the system? Is there any sanction for you? And also, what's the physical infrastructure for delivery? So all of those things are current debate, and they're all reaching various degrees of recommendation or resolution, but nothing is tied down at all. And the other thing which is out there is, before, you see now in the middle at the top line, health. There is enthusiasm for some parts of Cabinet at least to include health and disabilities as well as redundancy in the process. And that has caused quite a lot of debate, not a little angst, because while you can fund the likes of injuries and redundancies that are very low cost in terms of contribution, funding the health system is a government good right now, and it effectively requires translating what is paid for currently by taxes across to a contribution-based scheme, and I think everybody recognises that can't work. So you then end up having to either design a dual scheme or something else. So there's a lot of debate and no decision about how, the extent to which and for how long and when the health system might be included, but it is holding the discussion up to a lot slower level than we might have always hoped. So that's very brief. In terms of where it's at the moment, the working group is a multi-agency working group putting together all of the answers to these questions, or recommendations to these questions, that is due to report back to the Future of Work group, which is headed by Grant Robertson in August. And that would result, if there's a willingness, in a discussion document which would become publicly available for public consultation, probably through till the end of the year. And as a result of that, the analysis of all of that feedback would then feed into whether or not the scheme would even go ahead or not. Should it go ahead, there'll be another probably close to 12 months worth of work on design, because none of these things, there's a lot of insurance and other issues to work through as well. So an aspirational goal would be to have something in place in something like 2023 at the earliest. That's the level of conversation it's at. So nothing's set in stone, but it is a direction of conversation which, as employers, we can support, as opposed to the choice of having statutory minimum entitlement to redundancy. And we do believe that, provided it's restricted to those things that are economic displacement rather than health-based displacement, it's manageable. So time will tell. There's still answers to be found, but that's the direction of travel on the employment insurance conversation. Quickly on Holidays Act, we've all been through the pain of knowing that the Labour Inspectorate thinks we've not paid people correctly, or that we've got remediation issues to work through. And that still goes on. But there has been the review of the Holidays Act through 2018, 2019. The government has accepted the recommendations of that holiday working group report in full. So now the process is one of converting that set of recommendations into workable legislation. And that's going through a secondary process with another group, primarily made up of payroll providers and payroll type people, turning those recommendations into practical reality. In other words, does it actually work if you input it into a computer? Theoretically, yes, because that sort of person was used in the process of putting the report together, but it's going through another iteration of that testing to make sure that all of those recommendations can in fact be made in a payroll system, and also that they make sense, so that people don't make the sorts of mistakes we've seen in the past. So the idea is that we will see some form of legislation early next year at this point, and possibly passage sometimes towards the middle of next year, all going well. The last thing I just want to cover briefly is there is a lot of litigation in the system at the present time, a lot being driven out of things like the lockdowns and the wage subsidies. But there are a couple worth commenting on because they impact most businesses. Last week in the Court of Appeal, the Metro Glass case, which was the case that said that the bonus and incentive scheme that Metro Glass operated wasn't truly discretionary, and that the payments that they made to people should have been included in gross earnings for the purposes of calculating holiday pay. The Employment Court found that, in fact, discretion or discretionary payments should only exist in the most extremely limited circumstances, like the Christmas bonus, where the boss says, oh, for no good reason, I'm giving you all $100 because you've done a great job. That level of limit. Whereas it's very common right throughout the country for business to operate incentive and bonus schemes. A lot of them probably primarily at more senior levels, but they do operate throughout the economy at every level. And that decision, even if Metro Glass won its specific facts, would apply to every business in the country. And of course, that means going back in terms of remediation, every business that has been paying bonuses to its people and not including those bonuses in gross earnings would have a liability to pay back the gross earnings, the holiday pay that would have been correctly calculated if they loaded them in. Just as a ballpark figure of 20, I did a sample of roughly 20 odd companies as to what the level of liability they would face if this went wrong. That 20 companies alone total just under $400 million. So the obvious conclusion is that the liability across New Zealand is a lot bigger than that. And that's what's at stake if the Metro Glass case is not found to be, well, if the employment court is not found to be wrong in this case. The other one, Gate Gourmet, relates to the wage lockdown where the employees were sent home, and because they weren't working, they weren't paid, they were paid 80% of what they were paid before, as they'd agreed, but that 80% was less than the minimum wage. And the argument was that irrespective of what they were doing, you can't pay less than the minimum wage, which of course would have affected a great number of businesses, particularly small businesses who have, like cafes, restaurants, and other businesses that have a lot of workers at the minimum wage level. That went to the employment court, who upheld the business perspective. Business New Zealand was an intervener in both these cases, and upheld the view that you have to be working to get a wage, and what they were getting while they were at home wasn't for working, it was simply something the company had agreed to pay. That has now been appealed to the Court of Appeal, and that will itself have another potential impact on many, many businesses. There are likely to be more. There was, for instance, the issue of when the lockdown was first imposed. There was only 2 days to get ready to get completely locked down. And there was a mad scramble from businesses to work with their employees to do things like, can you work for 80% of your current wage, because that's what it's going to take to keep us alive. The Employment Relations Authority in this case found that 2 days was far too inadequate for a proper consultation process, and it found against a company who had been through that process and ordered them to pay full wages for everybody for the period, which of course would have bankrupted them. So that was to have been appealed, but in the meantime that company settled, and that question is now remains unresolved. I understand the union movement has a number of identical claims which it's preparing to proceed with. So that there are a number of live issues. And I guess I would make this point is that as the kind of voice for a lot of business in this country, and certainly the one that the government consults with most, we ask for both your support in terms of information and any other form of support you can find, because we're going to need to work together in relation to the impacts that will flow from a lot of these decisions, as well as the ones that flow from the fair pay agreements process in the time to come. So I'll leave it there. Hopefully I haven't been the complete Christmas Grinch, but any questions that flow through, I'm more than happy to take.
Or just going to the Metro Glass one, what counts as a discretionary bonus? Say, for example, one contract is written that not 3 or 5% bonus, depending on how the company performs or how you meet, which will take the guys. Is that discretionary, or is that part of your wage and salary and related to that? As well as the situation where a senior management team member might be offered, instead of an increase, a salary increase, will increase the percentage of the bonus, which would then become a component of your overall remuneration. So are they discretionary, or are they counted as part of this?
The question, and I'll paraphrase it, the question is, what really counts as discretionary? Is a bonus where you say got 20% of your remuneration at risk, and the boss says, well, I'm not going to give you a pay increase, but I'm going to increase the amount of bonus you might get in the future. Are those things discretionary? The starting point is the law itself, and the law says that something that is not in the employment agreement and that the employer is not bound to do can be discretionary. In other words, it can be excluded from gross earnings. So that can include something like what we would argue, because of course the employment court has said none of these things work, but we argued in the Court of Appeal that the idea of a bonus works in two ways. The court employment court said, if you've got performance criteria and performance indicators, even if the understanding is that a bonus is discretionary, the existence of performance indicators is a commitment to paying something if you succeed in meeting those performance indicators. Now, we argue that that's wrong because, for instance, I might have a set of performance indicators and I do very well on all of them, but the circumstances facing the business, be it COVID or anything else, are such that there is no ability to give me anything, and it's entirely within the discretion of the board or the chief executive to say, Paul, sorry, done well, but there's nothing to give you, you're not getting anything, is as legitimate as if I don't meet a single one of my performance indicators, but in circumstances that were so difficult that the chief executive or the board decide that recognition is still appropriate, and I do get a bonus. Both of those things ought to be possible, we argued. We hope that the court listened to that. But it does come down to, we believe, an interpretation of two things. One is there has to be nothing in the employment agreement that suggests that you will get something, even if there's no quantum. And secondly, there's got to be an ability for the authority or the decision maker to say anything or nothing is the outcome. Without those two things, it's arguable that those things are not discretionary and should be included in gross earnings.
Go back to the pay agreements. Talking about relativity claims, governance versus electricians. What's the relationship between pay agreements?
The question was, going back to the question of relativities and things like carpenters versus electricians, where does that stack up against fair pay equity settlements? First observation is that pay equity and fair pay agreements are roughly the same thing, is that they deal with an occupation. The difference, of course, is that with pay equity, the starting point is an occupation that is female dominated, and that there is a history of systemic kind of undervaluation of that group. So that's the starting point for negotiations. The outcome, though, of a pay equity settlement is two things. One is it is a settlement that group feels brings them up to a level which is the value that they perceive themselves as having. The second is, in the relativity argument, is it recalibrates the relativity. So, for instance, just for argument's sake, that all electricians were female dominated and they felt that they should have been paid the same as plumbers. Pay equity settlement achieves that outcome. Then the legislation for pay equity then ties the electricians to the plumbers, so that perchance the plumbers then achieve something in a pay deal for a fair pay agreement. The pay equity legislation will bring the electricians up to that level as well, because there is a legislative requirement to maintain the pay equity relativity that's been achieved by that settlement. So there are bureaucracies within bureaucracies within bureaucracies as far as these mechanisms are concerned. So while the outcome might be the same, the routes to them are different, and they tie to each other in ways that will be themselves probably a great vehicle for a lot of litigation. And for those that make their money out of the law, you're going to die rich and very tired. Any more questions? Do we have any on? I haven't chat. Where do I find the chat? I can't find a chat on here. Just looking for some questions online. Okay, so the first question I've got online is, do both criteria need to be met for a fair pay agreement, membership and public interest? The short answer is no, one or the other. So the membership one is either 1,000 workers that would be covered, or 1,000 members, or 10% of the workforce that would be covered. The public interest one is separate, so it's one or the other. Can Business New Zealand give a commitment that will not act as an employer bargaining entity for fair pay agreements? There's an interesting question. The answer is we don't want to. We don't think we should have to. Writing us in is an act of assumption on the part of the government. Now, whether or not, the question then becomes one of, if they cast us in a role with penalties, Where does that leave us? And that's going to create some very interesting and awkward dynamics, I'm sure, for the government. But the thing is, there's nothing fair about any of this. Having a default proposition might be how it worked in the past. But there's, as you can see, the mechanics of this, the practicalities of this, and the fairness of this are non-existent. And frankly, Business New Zealand doesn't want to be part of unfairness. So that's a very short answer to that question. If we look at, how do I? The question is, what's the chances of social insurance getting up before the next election? As I said, the aspirational goal was to have something working by sometime in 2023, which of course is election year. I think the government has some aspirations that would be a good news item, but there are so many fishhooks and so many unanswered questions that I can't see that there's any guarantee that it will happen on time for the election. I suspect it may well become an election issue. I'm looking for, Catherine, I can't find how to get these questions. Okay, so here's another question. What happens if more than one union initiates a fair pay agreement with both having met the criteria? Then there will be an arbitration process because the process of who can initiate is not tied down at this stage in law. What happens though if more than one union would have coverage, then there is apparently going to be some sort of process where those unions can join the coverage of the agreement as the thing is settled. So if, for instance, clerical workers, the PSA initiates and bargains for a union for clerical workers, I understand there will be some potential for unions that also cover clerical workers to join in to that process or join up to that process so that they are not left out of having their membership represented. Another question is, can an industry association decline to participate? My understanding is no. The way that it's written at the present moment is no. The only proposition for a default employer was, as I understand it at any rate, that where there was no observable or no industry association that was representative of the group that would be covered. But there's nothing yet, because it's only government's decisions at a very high level. There's nothing yet in terms of written criteria or drafting that says how that particular question will finally be resolved. Another question is, can you still have individual employment agreements if the employee wants to bargain with their employer individually? Yes, provided that it is not less than the provisions of the Fair Pay Agreement. In other words, everything that a Fair Pay Agreement provides will be the floor from which you can only bargain up, not different, up. Another question, I'll scroll down a bit. We've seen some landmark decisions recently with employees versus contractor relationships, with the authority moving towards the lens of employment. You note that it's unlikely we'll see any legislation on dependent contractors anytime soon. So how do you see business managing this risk until there is more clarity on what protections for contractors may look like? I think the short answer is as you are now, which is with difficulty, because there will be, and we're already seeing, an increasing number of challenges to the status of people as contractors versus employees. We've also already seen the work done in the film industry, where there's now a bill in the House that gives employment-like rights to people in the film industry. Even though they are still contractors, they will be able to bargain collectively, and they will have some rights, not including strike rights, in relation to some of the expectations that they can have contractually. The point I would make about the film industry, though, is that deal effectively codifies what they already do and have done for many, many years. The film industry operates on an informal de facto fair pay agreement, or MECA, if you like, that is a written document that has guided their activities for many, many years now. And really all that's happening with them is to bring that forward into some form of legislation. So that is not the same as everybody else. The film industry is a very mature, cooperative industry where the actors and the producers and the directors and the stuntmen and everybody else, the technicians, all understand how they work and how a film is made and how it works and what needs to make it happen. For the rest of the country, we're talking about uncharted territory because most people didn't work under the old award system. They've only grown up in the system that's existed since the 1990s. And so our population, especially our younger workforce, have never seen anything like this, and it's foreign to them. So short answer is to the question is you'll continue the way you are now with probably increasing difficulty because there will be more challenges. I'm sorry, that's not a good answer, but it's the only one. So the question is, how will we enforce fair pay agreements given the potential for potentially a lot of people to not even know that they're covered by one? Again, the short answer is the Labour Inspectorate will probably play a large role. It will probably be a case of a person who is covered effectively being dobbed in by somebody who sees that being the case, reporting it to a Labour Inspector who would then come in and make an investigation and reach conclusions that would either be taken through to the authority for enforcement action or perchance some form of a local level action at the Labour Inspectorate level. But it is, I think, a recipe for a lot of people not knowing that they're covered, being then told later that they are, and also then the potential, like the Holidays Act, for instance, a lot of remediation or past practice catching up on people being required to comply with it in a retrospective sense. So there's a lot of potential for that, particularly where there's a lot of businesses or a lot of people involved in a particular occupation or industry. So if we look down a bit further into the questions, see what else we have here. What's the next step for fair pay agreements? Do we have any idea on timeframes? The government tells us that it's keen to have them in legislation in the House by the end of the year. So in the meantime, what they're working with is through those various steps you saw in that diagram, I think I listed the initiation through to conclusion and the disputes process. They're now writing what's known as drafting instructions, which is recommendations to the Parliamentary Council Office who actually write the law itself to make these things happen. But I do know that they're grappling with a lot of the practical aspects of these and that they're having difficulty finding a way to express these things in legislation that actually works. So there is the potential that their own process will slow them up, but all things being equal, the government's very keen for something by the end of this year. Another question, why do you think we haven't seen any private sector pay equity claims yet? The biggest reason is representation. There is one private sector claim out there at the moment. It's in the early childhood sector. It's initiated at the state sector level, so kindergartens and the like. But as you will all know, anybody with kids will know, there are an awful lot of early childhood people out there in the private sector. There are 600 or 700 covered by the Early Childhood Council. There's Montessori, there's Rudolf Steiner, there's all sorts of other outfits out there. And quite frankly, they don't coordinate nor cooperate in much of anything. So a pay equity settlement for early childhood sectors requires a representative employer at the table, and at the moment there isn't one. They simply cannot get themselves together to cooperate on this claim, so it's going nowhere. And I suspect, like I've said for fair pay agreements, that this ability to coordinate representation in a meaningful and acceptable way is going to be the thing which stops an awful lot of this process. What else have we got? Do we have any view on which occupation or industry will go first? Given that unions initiate these things, then unions will make the call on who goes first, and they've made no bones about the fact that they see people like cleaners, security guards, shop retail, and so on being early contenders. Typically all of those ones that are paid on a part-time basis or a piecemeal basis or a minimum wage basis. There are a lot of those that they see. And so listening to the unions, you can expect that some of those will be quite quick. that's mainstream unions. There's a lot of others out there who have their own issues. So hairdressers, for instance, don't have any particularly strong union representation, but they do have some. And there's an interest in having a fair pay agreement for hairdressers. That will be interesting because back in the by the time 1990 came around, or I'll go back to 1894, there was one document per occupation. By the time we got to 1990, there were 3,200 odd awards, more than twice the number of current collective agreements. And that recognised reality, which was you can't simply have one size fits all. You need regional and local differentiation and so on to recognise the realities of life in particular areas. And so there will be some of those cropping up where people want to do something different. And again, as I said before, the government, while it might say we will limit the number of these, it can't. So while we've got information about what's on the horizon by the way of the big ones, like the cleaners and so on, so there is also a lot of others who might be there. A word on cleaners, this is an interesting one. Fair pay agreements are designed to prevent the so-called race to the bottom, the business about contracting and contracting, so that every time a contract's re-tendered, the price is lower. And of course, the people working for the successful tenderer get squeezed as well in terms of wage rates and the like. The cleaning industry is roughly half and half. Half work for companies that belong to the central organisation, and they're covered by a MECA, which is negotiated with the union. It's a fair deal, they're all happy with it. Roughly the other half of the industry is contractors, who are not going to be covered by fair pay agreements, and who are franchises and the like, who are out there in that competitive environment that is being complained of. That problem's not going to be solved by fair pay agreements because they're not going to be covered. So again, there are conceptual difficulties in the design of these things that sound good on paper, but when you apply them to reality, are simply not going to work. Another question. The government said the goal of a fair pay agreement was to counter the race to the bottom. I think I've just covered that point when it came to wage rates in industries that compete, such as bus drivers. Do you see any other mechanisms to remedy this issue? Well, the remedy is simple. That is to get that business and that entity and that industry around the people who pay the money and say what is going to work. That is why we have, that's what globalization brought to us in the 1990s, which is that businesses need to be able to compete at a level which is relevant to the business that they're in, relevant to the clients that they supply goods and services to, and relevant to the cost of what can be done successfully for everybody's benefit. And the idea is that everybody grows out of that. If we have a mechanism which is simply keeping people at the wall and not getting margin out of it, then nobody grows. The economy grows, doesn't grow, which is precisely what these things are supposed to achieve, apparently. But it's hard to see that they won't, that they will rather. It's perfectly possible for them to run concurrently. So I can see the engineers union, or sorry, the E2 running a claim for some trades, First Union running claims for drivers and cleaners. Yes, there's absolutely no obstacle on paper at any rate to a whole lot of these things happening concurrently. And so in the printing industry, for instance, sitting down with the Printing Industry Association and working through while the hospitality industry works with all of the cooks and stewards and the like in restaurants, there's no legislative, there's no apparent obstacle to a lot of these happening all at once. Well, as you saw from the diagram that I put up, there are many, many, many points of potential for litigation, and every one of those can lead back to an authority or an arbitrary decision being made. But every one of them, of course, will slow the process down. Yeah. Yes. Yeah, the big thing, the big difference with Australia is that Australia doesn't bargain. Basically, the Fair Work Commission, which is the central authority, receives submissions from the union and employer parties on a particular matter, and it then considers those and makes a decision, much as it would have if it was hearing a court case on the papers. So it is a totally different system that Australia operates, and the bargaining approach that is being chosen here has process issues with it, but as I said earlier too, it offends the idea of free and voluntary bargaining that's enshrined in international law that the government has signed up to. It is so blatantly in breach of that, it's not funny. And yet, if you read the cabinet paper that it authorises the drafting of fair pay agreements, it acknowledges those breaches and then says, but we think it's necessary. So in other words, they are openly declaring themselves in writing to the international world that they intend to ignore the commitments they made, which itself is a problem.
The unions must be funded out of this somehow. So members from the SPA, how are the unions being?
Well, the unions started off by hoping that they would be able to effectively clip the ticket for every person that ever got covered by a fair pay agreement, to the tune of even up to membership fees, so that whether they were members or not, they would be financially benefited by the volume of people covered. Cabinet's written that out, explicitly written that out as a must. But in other words, unions, there will be no mandatory requirement to pay anything in respect of people who are not union members, but who will be covered by the document that the union negotiates. That said, the government has permitted that to be an issue for bargaining. So in other words, you can expect it to be a claim in every fair pay agreement that the union wants some form of recognition for bargaining a deal that will cover a lot more than just its members. And it's been an aspiration of theirs, openly so, since the 1980s, 1990s. So you can expect that to be absolutely on the table. Yeah. The original proposal from the working group on fair pay agreements was that everybody, all workers, would be covered. The government, because of the work that's going on contractors specifically, recognises that there are still lots of fishhooks about how you classify people. So for the time being, has excluded contractors from coverage. I think you can expect that if there's any resolution of some of those contractor issues that tip people more towards employment, that you'll see a growth in the number of people that get covered. But it may be simply because they become employees and therefore automatically covered, or it may be there's an expansion like the film industry where people get rights, employee type rights, but without being employees. Those things are all out there still.
Under the ERA's
well, they're also talking about organisations.
Another question is Business New Zealand intending to raise likely breaches of ILO obligations at the ILO? The answer is yes, and we already have. There are a range of options there. At this stage, we have written several times to the ILO, who has in turn written several times to the government, to date with no response, asking what it is that they think they're doing effectively. But the levels beyond that are still available, which include making it much more formal and taking it to the various supervisory parts of the ILO. Those are the groups and committees that consider breaches and raise issues like sanctions and other issues. So those are all out there yet. But at this stage, until there's some finality around the government's proposals, at the moment we have cabinet proposals, which are fairly detailed, but with lots of questions unanswered. As we get closer to what the final thing will look like, we'll be able to be much more particular and much more targeted at that international level in terms of what options we choose and how we deliver them. Another question would be regarding the employer's ratification voting. What's the rationale behind the vote's weighting value? I have no idea, is the simple answer. That's something it doesn't make sense even at a numerical level. If it's okay for every employee to have one vote, then there are only that many number of employees working for employers too. So how an employer can in fact multiply their voting strength by virtue of being small by up to 2 actually distorts the weight of employees eligible to vote one way or the other in favour of employers, you'd think. But the mechanics of trying to find out who and what employers have how many employees, so you can actually estimate the accurate voting weight, is a physical impossibility given what's out there and who is not a member of anything. The vast number of employers, small employers, don't belong to anybody, nor does the vast majority of employees don't belong to anybody. So first they have to be found and then they have to be counted. It's just unworkable in my view. that's the end of the questions I have on chat. Is there any more from around the table? So I'm having fingers pointed at watches and clocks here. So I think we'll wrap it up there. And thank you very much for attending. It's been great to talk to you. Hopefully, if anybody has questions, flick them through to Business New Zealand, through to Catherine, who organised this. And if then she passes them to me, I can certainly give you responses to any other questions you may have. Thank you for attending.